Yeah, let's hear about your first trial in California. Tell me about that. What was that like?
I was only about 25 years old, fresh out of law school, and I got railroaded into second chairing trial in Stockton. So I had to drive from Santa Rosa to Stockton every day, which is hours, by the way. It was a very interesting case. It was a case against a chiropractor who had had his license taken away from the Board of Chiropractic. He had been running a scam throughout California because he had many, many offices. And the scam was to advertise a free exam. And so it was in the time of newspapers, because this is 25 years ago. And newspapers would say free chiropractic exam, and it would advertise his clinic. And unsuspecting people would go into the clinic and they'd say, I'd like my free exam, please. And people would go into the clinics and that doctor would say, okay, come on in for your free exam. And they'd say, okay, move your neck to the right, move your neck to the left, okay, lift up your arms. That's the end of the free exam. And now we're going to proceed. I think we should get some x-rays done.
And then they charge them for the other stuff.
And then the person would walk out with a bill for $300 or $400. Someone who had come in for a free exam because they couldn't afford, an actual paid treatment. And so our client in that case was started off as a Jewish Auschwitz prison camp survivor. His name was Adolf Pickler. And he even had
What?
his name was Adolf Pickler. Yeah, I know. Sounds a little bit like the bad guy, but it's quite the opposite. He had the Auschwitz prison camp tattoo on his arm, the numbered, because of course they would give the Jewish prisoners the numbered tattoos. And he was very, very poor. He and his wife Lydia were very, very poor. And so that's why they had responded to this advertisement for a free exam. He was, I believe, in his 80s at the time and had, all sorts of creaks, aches, pains that 80-year-olds have, and thought that a free exam for someone like him who couldn't afford anything was a nice gesture for this nice chiropractor. And again, he came into the office. The chiropractor did the, okay, bend your head right, bend your head left, end of free exam, and let's proceed. And so in any event, he walked out with a bill for $332 and couldn't afford to pay it. And so he came to the firm, and the firm investigated, looked at what was happening, and said, hey, this is not right. And we're going to bring a case for unfair business practices under the California Unfair Business Practices statute. It's technically 17200 of the Business and Professions Code, unlawful, unfair, fraudulent business practices. And with the Unfair Business Practices statute, you can get your money returned to you, as well as the lawyer can get paid if they win. In order to get paid, you have to prove that you benefited the general public, that you provided some significant benefit to a significant number of people. So, in any event, while the case was proceeding, Mr. Pickler passed away, and the case proceeded on behalf of his estate by his wife. So his wife continued the case as our client. And her name was Lydia Pickler, and she was this beautiful little old lady. I'll never forget a couple of things about her. Number one, every day of the trial, I would take her out for chicken soup. There was a little chicken soup place next to the courthouse, and she would just love her chicken soup. She was 80-something. But the thing that I'll really, really never forget about Lydia was when we were in court one day, and I was cross-examining the head chiropractor, the lead person who had basically promulgated this scam throughout, it was 5 or 6 different offices located throughout California. And I was cross-examining him on all sorts of things. And I can't remember exactly what moment it was. I believe it was when I was cross-examining him about the quote-unquote free exam that he had offered. And I had been asking him about, well, you didn't make it clear to people like Adolf that the free exam was over. And he said, oh yes, it was made very clear to all of our patients when the free exam was over, and we informed them that we would be charging. And as I'm a very young lawyer, about 25 years old, in front of a very kind but stern-looking judge. I still remember he wore this big gray beard and looked very stern, and it was, of course, a little bit frightening as a young lawyer to be before a judge that looks stern and menacing. But I'm in the middle of cross-examining this bad guy, so to speak, and what do I hear from the back of the courtroom? Little Lydia Pickler had stood up and started waving her fist, shouting, "Liar! Liar!" And I remember turning around going, oh no, what happens now? And the judge was very nice about it. The judge kind of just looked at me and my co-counsel, another great lawyer at the firm, his name was Bob. And since I was the one cross-examining the chiropractor, Bob, kind of quickly shuffled to the back of the courtroom and told Lydia that she needed to sit down, and it wasn't permitted to stand up and start screaming liar. But you have to appreciate that. I mean, she was a little old lady defending her husband's honor, her dead husband's honor. So in any event, I'll never forget her, because that was the one time. I've been in dozens of trials since then, and I've never had anyone quote unquote disrupt the courtroom quite like that. Stand up and scream liar. There's been plenty of times I wanted to point at someone and say liar, but that's a rule in trial. I'm going to digress a little bit from that story because one of the things they teach young lawyers about going to trial is that even if you think you've caught the witness in a lie, you don't call them a liar. And the reason is really simple, and it makes sense when you hear it. The reason is, if the jury who's sitting off to your right or left thinks that that witness is a liar, you don't need to say it. They already think he's a liar because you caught him. If they don't think he's a liar, or she is a liar, and you call them a liar, well then now you're the bad guy. You're a jerk. So you never call them a liar. You can maybe raise an eyebrow, you can maybe use some body language that suggests you don't really understand how what they just said could possibly be true. You could act confused, but you don't point and say you're a liar. Or in closing argument, you don't say that witness was a liar. You can say, what they said was false. You can say what they said was inaccurate, a misrepresentation, but you generally don't use the word lie because of all the ways that word is loaded. We're taught from a very young age, liars are bad. And sometimes jurors can be very forgiving of people who get things wrong, because we all get things wrong sometimes. And so if you call the person a liar and the jury likes them, then you're the bad guy. So you don't call people liars. But my client, Lydia Pickler, didn't mind standing up and calling that chiropractor, his name was Lester Simmons, calling him a liar. The case is called Pickler versus Simmons. You can actually find a Court of Appeal decision on that case, because it was the one time I ever appeared before the Court of Appeal. So when that case was over,
And it was your first case.
and it was my first trial, when the case was over, the judgment was for $332. That's it. And then we had to go before the court and justify why we, the firm, should get our fees and costs, all the expenses that we had incurred, which to go to trial is a significant amount of money. And this is back in 1999. And in 1999, well, let me back up. Right when the case ended and we got a judgment for just $332, not a lot of money, the partner of the firm, who I had been trying the case with, he left the firm. And he had tried in that case to get more than $332. He tried to get a fraud award, but the judge said that Adolf did not bring the case, that's our client, did not bring the case in time to get a fraud claim because the statutes and limitations are different for fraud and unfair business practices. It gets complicated. The long story short is the senior partners of the firm were not really that happy that we spent a month in trial and we only got $332.
What were the fees?
Well, yeah, I'm going to get to that. So the partner that I had been working with on the case that I had been, assigned to assist him in trial, he left the firm and moved on to another firm. So I was the only one who knew anything about this case that had been a massive time suck for the firm that I had fairly recently just joined. And all I had to show for a month of trial and a massive amount of expenses and everything else is a piece of paper saying that the defrocked chiropractor owed us $332. And so I had to apply to the court to say, well, we got $332 and an injunction. So the injunction is something where, an injunction means the court saying something has to happen or can no longer happen. And in this case, we got an injunction, an order from the court saying that this business practice could no longer go on. You could not offer a free exam unless the entire exam, when the person was in the office, was going to be free. You couldn't basically bring someone in under the auspices of a free exam and then halfway through convert it to a paid visit. So we had a court order issued saying that this chiropractic scheme could not go on anymore. So, armed with the fact that we got the injunction stopping this practice, I actually, because the other lawyer left, I went to court and I made a motion before the court saying we benefited a large segment of the general public because this scam was being perpetrated throughout California in about 5 or 6 different locations.
Stops everywhere.
And it stops everywhere. And so I said we benefited enough of the general public that the chiropractor should owe us all of the fees for stopping him. It's under a statute called 1021.5 of the government code, and it's the private attorney general statute, which basically says that the statute says if you benefit a large number of the general public, then you should be paid for that as a lawyer, because you're essentially working on behalf of the people. Mm-hmm. And that's why it's called the Private Attorney General's Act. So you're kind of acting as a private attorney general when you're trying to stop an unfair, unlawful business practice. The long and the short of that motion is that the judge granted it and awarded us about $330,000 in fees and costs to the firm. So I was a hero. I mean, I'm just this 25-year-old kid who basically from the jaws of defeat managed to turn a $332 judgment into $330,000 for the firm.
Holy shit.
And so because of course the defendant didn't care about the $332. He didn't really even care about the injunction because he had his chiropractic license taken away. So he couldn't do it anyway without trying to get his chiropractic license back, and that was not likely to happen. So what did they fight us on? They fought us after that on the issue of whether we benefited the general public and whether we as the firm deserved the $330,000 award. Well, the defense lawyers, the lawyers for the chiropractor. So they filed an appeal, and I briefed the appeal. It was the only time in my 30 years as a lawyer, almost 30 years as a lawyer, that I ever did anything with the Court of Appeal. I've always been a trial lawyer, not an appellate lawyer. But I was basically just handed this case as a 25-year-old saying, do something here. First get us some money, and I got us money. Now go protect our money. So I had to figure out how to do the whole appeal defense thing. So what was really interesting about that was that the case was chosen by the Second Appellate District Court of Appeals in California to be part of the Court of Appeals community outreach. They chose just a few cases that had very interesting fact patterns, because a lot of legal cases are very dry. But as part of the community outreach program, the Court of Appeal chose this case to be part of a community outreach program where the appellate arguments, the arguments in front of the Court of Appeal, would be in front of a high school. So I went to the Amos Alonzo High School in Stockton, where the whole auditorium was packed with high school students.
Wait, why were the high school students there?
Because it was part of the Court of Appeal outreach program. It was basically like, hey, let's show the high school what happens in real Court of Appeal.
Spectating.
Yeah, they're just spectating. So, but it's a big auditorium, and it was just packed with these high school kids. And the defense got up before the three-judge panel. 3 Court of Appeal judges are sitting on the auditorium stage, and the defense has his table and I have my table, and the defense gets up and basically argues all about how I didn't really benefit the general public, and that we don't deserve our fees, and all of these things. And then I got to get up, and because of the way this chiropractor had particularly scammed my client, an elderly man who is now being championed by his little old lady wife, a man who survived the Auschwitz prison camp to come to this country, to live poor and be scammed by this chiropractor who was making ungodly amounts of money ripping people off. And so I was very impassioned, which is also probably not as common in Court of Appeal arguments. Court of Appeal arguments are usually very dry because they're usually very much about what the law is, and there's not a lot of passion and facts being discussed, in a perhaps as vigorous a way as a young 25-year-old might argue them. And so I remember just being very passionate about how we were able to stop this practice that was ripping off, that was essentially stealing from poor people who couldn't afford health care. And at the end of my argument, I went to go sit down, and the auditorium erupted with all these students cheering and clapping and like hooting and hollering about, in favor of what I had done. And so it was a really neat moment to use my words to stop an injustice and to champion the rights of people that couldn't speak for themselves. In any event, I won. And
do you know what your closing argument was?
Well, it was really just about how I spoke about the record. I spoke about what we had proven in trial, because what is proven at trial is the record that the Court of Appeal relies on. And so I had proven that this chiropractor was running this scam even after, by the way, he had lost his chiropractic license. Actually, I had forgotten about that. Even after he had lost his chiropractic license, what he did was he just continued ownership of these clinics and would hire other chiropractors to run his scam for him, even after the chiropractic board took his own license away. It's not illegal to own clinics as long as you're not scamming people.
Well, was there legal precedent for the scam yet? Like, did it?
Well, you can never, I mean, I don't know if what you mean is, was there a law against the scam? I mean, not specific. There's no law against everything that is an unfair business practice.
Yeah,
That's why we had to bring the case to say, hey, this is not right. So the law is the general law that you cannot be unfair and deceptive and fraudulent.
Did you prove that this was a scam? Yes.
Well, we proved that at the trial level. So yeah, and the court found that it was unfair, fraudulent, unlawful business practice. So I essentially spoke to the Court of Appeal about how we did benefit the general public, because even though this chiropractor had his license taken away, this scam was still being perpetrated throughout California, and we stopped it. And because we stopped it, not just as to our client, but we stopped it from continuing to happen to other unsuspecting, poor people like our client from being scammed like that. And so in any event, the Court of Appeal agreed that we had benefited, particularly because there were offices throughout California that were running this scam. We had benefited a large enough segment of the general public to sustain our award of fees, which, of course, you know, it was incredibly meaningful to me that I was able to champion that. It was also, to be honest, of course, meaningful to me that I got to go back to the firm and be like, yeah, we made $300,000 doing something, you know, that had looked like a loss. So to the firm, you know, I had to answer to the senior partner of the firm. His name was Dan Lanahan. He passed away a few years ago. And he was a New Yorker that seemed like a mob boss. And I don't mean that in a bad way. I mean it in the way that he was a man of few words, but whenever he spoke, everyone listened. And he kind of sounded like this. And so I remember before the Court of Appeal argument, you know, we were at a firm picnic, and I remember, you know, telling him, you know, I'm a little nervous. I have this Court of Appeal. I've never done, you know, an argument before the Court of Appeal before. And I remember him saying, don't worry about it. The case was pretty much, you know, a loss, and anything you can do now, you just be a hero. So I came back to the firm a hero, and that was pretty cool. And it sort of cemented very early in my career at that firm that, you know, I pulled this rabbit out of a hat and made the firm some money. They gave me a nice bonus from that case that I used to pay off a significant chunk of my student loan, which was nice. What else can I tell you about that case? Oh, the lawyer that I worked with on that case, that tried the case with me, his favorite story about me in that case is on the first day of trial, we were walking up to the little water cooler that was on the side of the courtroom, and it was before the judge came in. And the defense lawyers in this case were dicks. They were really, they were very serious, very kind of mean and nasty defense lawyers. They were much, much older than me, and even the lawyer that I had been working with. Like these are like 60, 70-year-old defense lawyers who had, you know, clearly had mountains of experience. And this chiropractor had a lot of money, so he was paying two very experienced trial lawyers. I remember on day one, we're going to over to the water cooler to fill our little water cups to have at our counsel table. And I said to Rudy, one of the defense lawyers, who was the oldest defense lawyer, I said, how many cases have you had? How many trials have you done, Rudy? Because I was just excited to be in trial. I'd always wanted to be a trial lawyer, and this was like my first time in trial. And it's day one on my first time. I was all excited, and I said, "Oh, how many trials have you done?" And he just, very like sternly is like, "I don't know, dozens and dozens." And and the way my colleague tells the story. I just responded gleefully, "This is my first time." So that's his favorite story to tell, was that I was just like, "How many trials have you done? This is my first time." And of course,
did he respond with anything?
No, he just and went back to counsel table. They were not friendly with us. I was just, being an excited young trial lawyer in my first time. So in any event, it probably stuck in their craw a little bit that I ended up beating them on my first time. So yeah, that'll always be a pretty neat memory of that case. Yeah, a lot of good memories from that.